Good morning, everyone, and welcome to the Northern California Pre-Recruitment Conference of the Association of American Law Schools. My name is Jonathan Glater. I'm the Associate Dean for Teaching here at Berkeley Law. I am supposed to introduce our Dean to you to give welcoming remarks, but our Dean was on a 6 a.m. East Coast time flight back here this morning after his flight yesterday afternoon didn't go. So he's going to greet you at 12:30 instead of now. You're going to get me as a poor substitute. But I will quote him, I think, with safety on the one point. I have heard him say that being a law professor is one of the best jobs, if not the best job in the world. I suspect he's going to say that to you at 12:30 as well. So we have an incredible lineup of speakers for you today, and we've built in lots of time for questions. And I want to provide just a little bit of context before introducing our panelists and handing the first panel over to them. It is a remarkable time to be a law professor. Every day, sometimes several times a day, questions that we grapple with are the stuff of the news, not always in a good way. In fact, often not in a good way. Not surprisingly, applications to law schools have increased. I should note that being a law professor does not only involve careful reading and analysis of legal texts, laws, judicial opinions, for example. Often we're working together rather than in isolation, both to help the law school to function and to address real-world events. Law professors write amicus briefs, they write op-eds, they represent clients, and we also teach, right? Teaching often, right, I think doesn't get the attention that it should in conversations about entering the legal academy, so that's why one of our panels is devoted to that. And it's fairly time-consuming. So if these kinds of activities sound exciting and rewarding to you, those of you who have not already had experience on this side of the podium at a law school, then you're in the right place. My hope is that the three panels today will help demystify the process of entering the legal academy as an instructor. In terms of format, each panel is scheduled to run for an hour, about 10 minutes for each panelist, and then the balance of the time for Q&A from you. So please think about the questions that you want to pose. There'll be a 15-minute break between each panel and a 90-minute break for lunch, which will be available out here where the coffee and snacks were. And then you can bring that, I've been told that you can bring the food back into the classroom to eat, or if you want to go outside, you can go out and around the corner and down the stairs to the plaza. Our first panel is exploring pathways into the profession, looking at what we call doctrinal teaching, clinical teaching, and legal writing teaching. Second panel will cover scholarship from the perspective of members of a faculty appointments committee, the body that reviews applications for jobs. And the third panel will delve into teaching, the actual pedagogy of law schools. So with only a little bit more ado, I want to introduce the panelists who are sitting on each side of me. Let's see. I'm going to make this simpler. I was about to make it complicated. To my immediate left is Emily Strauss, Associate Professor of Law at UC Law, San Francisco. To her left is Morris Ratner, Provost and Academic Dean and Professor of Law at the University of California, College of the Law, San Francisco, UC Law, SF. And to my right is Alina, Clinical Professor of Law and Director of the Social Enterprise Clinic here at Berkeley Law. A link to each of their bios should be on the workshop's website. Again, each will speak for about 10 minutes on the general theme of pathways into the profession, and then we will break for questions. Before I hand it over to them, I have a couple of questions for all of you. How many of you are on the market this fall? Okay, so just how many are thinking about going on the market next fall? And how many of you are kind of curious looking further down the road? Okay, so a decent mix. Okay, great, that's super helpful. Thank you so much. And thank you also to those of you who responded to my email explaining your interest in the legal profession. It was just literally heartwarming to read those. I will now hand it over, I believe, Dean Ratner is first.
Thank you very much. Is this mic working?
Oh, you have to push the button.
How about now?
Yes.
Okay, thank you all very much. Jonathan, thank you so much for organizing this panel and inviting us to participate. I am Morris Ratner. I'm the Provost and Academic Dean at UC Law San Francisco, formerly UC Hastings. I graduated from law school in 1991, joined a big defense firm in San Francisco, switched to being a plaintiff's lawyer, became a partner in that law firm, and mid-career in my 40s decided to become a law school professor, and did that first by doing guest lectures in other people's classes, including an ethics class here at Berkeley, then taught a single class as an adjunct professor, and then did a visiting assistant professor fellowship type program for 2 years where I was trained to do more academic scholarship and was teaching full-time before I got my current job at UC Law in 2012. That is one pathway. That was the pathway I took. So what I'm about to do is, from my vantage point as Provost and Academic Dean, where I manage the overall faculty governance processes and academic program, including the hiring processes, and where I study the hiring process at other schools, not methodically, but more because I'm paying attention to it nationally. I'm going to give you my take on the broad array of pathways that exist into teaching positions at law schools. And because it's just what I've learned over the years, I assume that others on my panel or others in the audience who have a different vantage point will chime in during the Q&A and add their perspectives if that is helpful. So most law schools have a mission. That mission has 3 elements: teaching, research, and for most law schools, some form of public service. Some faculty members advance all 3 mission elements, and others advance a subset of those elements. The American Bar Association is the primary accreditor for ABA accredited law schools in the country, of which there are about 200, and they have what are called ABA standards that structure much of every law school's academic program, including faculty composition. So some of what I'm telling you is dictated by the ABA, and some just varies by law school. There are to understand pathways into law teaching, one has to understand what the pathway leads to. There are 2 types of teaching jobs. There are contract positions, which are positions that are typically term contracts for a period of time that do not have tenure, but may have some other form of security of employment. And then there are what we call tenure track positions. Those are primarily, but not always, research positions where faculty have a mix of teaching and research scholarly production obligations. In the past 10 to 15 years, my sense is the biggest growth in job positions in the legal academy has been on the contract side, and hiring on the tenure track side has remained relatively flat or fluctuated a little bit up and down over the years. So I'm going to spend a little more time talking about the contract side because it's less visible. Unlike the tenure track side, there isn't a centralized data tracking about what's happening. There isn't a centralized hiring process run through AALS. And so I'm going to talk about 2 facets of teaching positions, comparing contract to tenure track, and also talking about some of the variations within the contract positions. First, I'll talk about the different pathways. Then I'll talk about some of the different conditions of employment that anyone interested in law teaching should be thinking about. And then I'll talk briefly about the duties and scope of the roles of contract faculty and tenure track faculty. In terms of pathways, for contract faculty, the pathways are incredibly diverse. AALS does not typically post all contract faculty positions, and the jobs are mostly found by searching law school websites for faculty hiring positions that take a variety of forms, as I'll mention in a second. Whereas for entry-level tenure track, there are posts on every law school's website, and also there's the AALS and SEALS, also a law school association, that have much of the same data and provide information about candidates that law schools can access in a centralized way, and give candidates information about law schools in a centralized way. In terms of the conditions of employment in law teaching, there are several factors to bear in mind as you consider which pathway you want to pursue, or if you're already on a pathway, which job you want to take if you have multiple offers. For the contract, the easiest one to talk about is tenure and tenure track faculty. They have security of employment comes about as a result of getting tenure after some period of time. Tenure is primarily based on your scholarship in teaching as measured by the law school's tenure standards. When you're on the job market, you want to know what the timeline is to tenure, what the minimum number of articles you have to publish while on your tenure track, whether their tenure process is transparent to the candidate or not, whether they have a nurturing culture where they really try to make sure all the candidates succeed, or they have more of a judgmental culture where they're trying to make sure you're up to snuff, because that could really affect the quality of your experience. In terms of governance rights, tenure track and tenured faculty have maximum governance rights. Governance rights are the right to control and duty to control the academic program, including things like academic regs and hiring. And tenure and tenure track faculty typically have the broadest scope of such rights. Not contract length. The length of the academic year is another factor to consider when thinking about which pathway you want to choose. Tenure and tenure track faculty are typically on what we call 9-month positions, meaning they teach and are expected to be on campus during the fall and spring semesters if it's a semester system, but they get 3 months in the summer where they are technically not teaching, but that doesn't mean they're not working. They're doing research typically over the summer months. In terms of teaching load, tenure and tenure track faculty, because they have research obligations, generally have teaching loads that are somewhat lighter than contract faculty. And in terms of compensation, faculty in the tenure and tenure track, tenured and tenure track positions typically have somewhat higher salaries than faculty who are in contract positions. And I'll talk about what that looks like. But the elements of compensation when you're thinking about teaching include things such as your base compensation, the ways in which compensation grows over time, such as through merit adjustments or general salary adjustments, the possibility of grant stipends and income from third-party funded research, professional development accounts, and for tenured and tenured track faculty, summer research stipends, and the possibility of getting chairs. And then tenure and tenure track faculty typically have the opportunity to get research leaves or sabbaticals, breaks from teaching even during the regular academic year where they're supposed to be focusing on research projects. So those are the basic conditions of employment for tenure and tenure track faculty. Let me, I'm worried about going over time, but let me briefly talk about the conditions for contract faculty. They are quite varied. So when you're looking at a contract faculty position, you want to know if there is a possibility of something analogous to security of employment. That could be achieved through the length of the contract. Longer contracts provide more security, or through provisions in a contract that make the contract presumptively renewable, so you don't have to worry about renegotiating your contract every X years. It just automatically renews absent some issue. You might be interested, if you're interested in governance, in the degree to which contract faculty members can vote on matters that other faculty vote on, whether that voting is limited or expansive. And you may also be interested in whether you're on a 9-month or a year-round teaching contract. Regardless of contract length, you could be a contract faculty member who only actually teaches in the classroom 9 months a year, or you could have summer teaching or other obligations. In terms of compensation, there's always the posted base compensation, but you're always interested in knowing about how compensation is adjusted and whether there are elements of compensation above the base that's listed on any job post, such as the opportunity to earn additional grant income or administrative stipends, depending on the type of work that you're doing in addition to teaching. And so those are the key elements of the conditions that you want to look at when you're thinking about different pathways. And the one piece that I haven't put on the table that I quickly will is that tenure and tenure track faculty have a scope of role that is different from, may overlap with, but is typically a bit different from contract faculty. in some cases, but not all cases. So tenure and tenure-track faculty are expected to teach, do research, and do faculty governance work and other forms of public service. Contract faculty could have some of those or all of those obligations, but may have an even wider variety of obligations. Within the cohort of contract faculty are clinical faculty who are not on tenure track. Some clinical faculty are tenure track and research faculty, as Professor Ball will talk about, as well as what we call doctrinal contract faculty. They just teach regular substantive law classes, but they do that full time, as well as what we call skills faculty, which could include legal writing faculty or academic support and skills development faculty. And I'm giving you archetypes, but often there's a lot of blended structuring going on. And some of the contract faculty teach and also have administrative roles. Some of the faculty at my law school who are contract faculty have some of the most interesting jobs on campus. They run our faculty-led academic support department. They run non-JD master's degree programs. They run centers where they do amazing research that's grant funded and teach. So when I was just pivoting from law practice to the legal academy, I didn't know about this contract option, and that's why I'm emphasizing it, because I've learned subsequently that it's a really rich vein for anyone interested in transitioning. The last two things I'll say are that there are transitional roles that I just mentioned that I had. They are contract positions, fellowships, or visiting assistant professor positions that have some of the elements of contract faculty. They're term positions. They don't lead to tenure, but they're transitional because they're designed to help people who have not had a full-time teaching job and who want to be research faculty transition to that role. And there are plenty of sources of information. There's been a huge proliferation of these types of fellowships and VAPs across the country in recent years. And I personally would never have been able to transition but for having done a visiting assistant professor role. So I strongly encourage folks to think about it. And lastly, we're talking about entry-level positions in teaching, but there are lots of interesting non-teaching positions in law schools that are scholarly, give one an important platform and position to engage in the law school and in intellectual debates writ large. For example, law schools have centers where they have people who are either on hard funding or grant funding who are doing policy work or research, and they are technically non-teaching academic staff. We do not call them faculty, but they have a rank in our faculty rules, and they are important members of our law school and of the legal academy. And with that, I'll pass it off.
Thank you, Morris. Oh, okay. Am I on? Yes. Yes. Okay. Hi, everybody. I'm Emily Strauss. I work with Morris at UC Law SF. I'm an associate professor. I am a tenure-track doctrinal professor. And I think in light of everything that you've just heard, I'm going to tell you a little bit about the journey that I took to get there, because I wore a bunch of the hats that Morris has spoken about on that journey. And then I will give you some random bullet points of advice that are hopefully a jumping off point for the Q&A later, if that sounds good. So my story is that I started as an associate, a litigation associate at Sullivan & Cromwell, and I moved to Duke as a legal writing professor. And it started out as a temporary role. I didn't think I was going to do it forever, but it became a permanent role. They needed to fill the role while somebody was off on maternity leave, and it turned out that they needed somebody to continue in that role. I did just that for about 2 years, and then after that, I started teaching financial regulation. And that may sound like a strange pivot, but I worked with a lot of financial services clients while I was in practice. The way that happened was that we had a professor at Duke who taught financial regulation. It was a popular class. He was looking at retirement. He wanted somebody to sort of start filling in, and I had the background and was able to do it. So that was the first sort of big non-legal writing course that I took, and it was sort of a standard lecture-style doctrinal course. After that, I continued to sort of add business law courses. I taught securities litigation and enforcement. I went on to teach business associations. For a while, I taught these concurrently with legal writing, but eventually I sort of moved over to where the business law classes were all that I was teaching. During that period, I started to write. And so I was in an interesting position, which was that I was not a VAP. I was not holding any kind of fellowship. I was contract faculty, and I was partly legal writing faculty. I was partly also teaching sort of bigger doctrinal classes. But I was in this environment where, you know, other people were writing, and it seemed like something I could do. It was something I had wanted to do and was interested in. And so I started to do that. So I started to write, and I started to publish during that time. I decided that I wanted to become a tenure track academic. At that point, up until that point, all of my positions had been contract positions. And it was an interesting process for me, something that I'm sure there will be plenty of questions about the market. For tenure track faculty, there's a big centralized market. It's an experience. We'll talk about it. But something that I think is sometimes less well publicized is that even for new entry hires, you can get off the market offers. And so I had 1 year where I was sort of thinking, okay, I think I would like to be a legal academic. I hadn't gone on the market, but I did have papers ready. I did have sort of a portfolio, and I got 2 off-the-market offers in that year. Neither of them worked out for sort of family-related reasons, but then the following year, I went on the academic market, and I wound up, after a long time, coming to UC Law San Francisco. So that's sort of my story and kind of the hats that I wore to get to where I am now. This is my 3rd year at UC Law SF. It's been good so far. I think for those of you who are interested in tenure track positions, for those of you who might be in some kind of capacity at a law school already that is not a tenure track position, but maybe you want to get there, I just have sort of a sprinkling of advice to give. I know that one of the most difficult things about getting into being a tenure track professor and doing that doctrinal work is writing the papers, right? If you're in practice, this is extremely difficult. It's partly difficult just because you don't have the time. It's also difficult because your brain is completely engaged in sort of the everyday pragmatic problems. I will say the everyday pragmatic problems are hugely interesting to academics. You just have to learn how to frame them. A lot of academics have been sort of soaring in the ether above the nitty-gritty problems for quite a long time, and they find the problems really interesting. But learning how to ground them theoretically and in the literature, I think, is the tricky part of trying to write papers coming from practice. With respect to that, I will say it's important to sort of get a sense of what your field is. And I know that sounds really obvious, but every field has a deep and wide seam of literature that you have to know if you're gonna do this. You have to know it in part to write the papers, right? That's how you ground your papers, that's how you make your practical experience interesting and relevant to an academic audience. But you also have to know it because in the end, that is how you network, which I think was not super intuitive to me when I started out. But what I found was that the best way I found to network was to write my papers, to cite a bunch of people in the literature, and to send my papers to those people. And that, you get sort of mixed results on that, right? Don't be discouraged, not everybody will respond to you, but a surprising number of people do. And that is great, because that means that when you go off to a conference and you meet these people, they know who you are, and they have sort of a work to put to a face. You know, they know who you are and what you do, and that is a much more powerful position to be in than just sort of going off to a conference and kind of mixing and mingling. You should do that too. But I will say that, at least for me in my subject area, which is securities litigation, and I realize fairly niche, I found it extremely helpful to have sent off my work to the people that I cited, to have their comments, and then go to the conference and be able to introduce myself and to say, oh, I thought about this thing that you said about my paper. And I think for me, again, I'm speaking only from my personal experience, that was the primary and best way I found of building my network. I think also, ultimately, if you are interested or if it's possible for you to do off-market offers, that's how you get there. It's because you have a network and because you have a reputation prior to going on the market. It's because people already sort of know you. And so that would be sort of my number one piece of advice, is learn the literature. It's hard, but it's kind of it's one of those things that you do, it's the worst at the beginning, you get it together, you have it, you continue to add pieces, but that heavy lift is at the beginning, and then you will always have it. And then cite those people, send your papers off to the people that you cite. Then go to the conferences and meet them and introduce yourself. So I would say for me, that's been my sort of number one thing. With respect to moving from being in contract positions, and I didn't really plan to talk about this, but now that Morris talked about it, I'm gonna. With respect from moving to from contract positions to a tenure track position, what I would say is probably you will have to go on the market or have some kind of off-market offer experience. Which is fine. I think one of the great things about being in that situation is that you were already in the environment, right? You were already in the legal academy if you are in a contract position, and you are in a place where you can go and talk to people and knock on doors and develop mentorships and all of that good stuff. And if that is something that you want to do, I strongly encourage you to take advantage of those environmental factors. That's a huge bump up from being in practice, right? In terms of networking and learning capability. I will say, okay, this is another sort of quick note, and I'm only saying this because I did not do a fellowship or a VAP. I did have this sort of long period as contract faculty, which I think for me was sort of analogous. But if you are doing a fellowship or a VAP program, sometimes a lot of those programs explicitly require you to teach legal writing while you are doing research. And that can be a little bit tricky. Legal writing is a fairly labor-intensive thing to teach, but that is how a lot of the systems are set up, and you just kind of have to be prepared for that. There are other VAPs, I believe, where they have you teaching things that are more in your lane, right? They're less sort of generalized. Some VAPs even, make sure that what you're teaching is a seminar, so it's not, a huge class, and it's something that you can really tailor. Don't underestimate the teaching part of doing a VAP or a fellowship. It is a lift, I think, no matter what you are doing. As someone who has sort of done the process of, teaching while also trying to start a body of legal scholarship. Okay, do I have anything else? I am unsure about the extent to which I should talk about the market process. How many, show of hands for people who are, okay, I'm seeing some thumbs up, some do it, okay, I'll do it. Okay, so like I said, the off-market process for me was very network-oriented, and I think that I would expect it always to be like that. The on-market, the sort of centralized market process is insane. And I think it has become more insane since the pandemic. I believe that, prior to the pandemic, there was a centralized location, and so there were sort of limits to the number of screening interviews you could do because you had to go to a place and actually show up. That's no longer the way they do it. You do screening interviews primarily by Zoom, and that means that you can have a lot of them. And I do not remember how many I had, but it was a lot. It was probably in the 30s or something, really a lot. Screening interviews are they're not a huge heavy lift if you're prepared. You need to sort of get your spiel together, be prepared to talk about your scholarship, be prepared to talk about who you are academically and where you plan to go, what your teaching interests are, and your job talk paper. This is sort of a 20-minute thing that you can get together, and you use it again and again and again, and try not to have a screening interview while your child is napping and might wake up, because that doesn't work out very well. So screeners, you can have a lot of them. Schedule them carefully. Make sure you have your spiel sort of locked and loaded and ready to go. Going for job talks, you can go for a few, you can go for a lot. I was in a situation, I'm part of an academic couple, and so there were some offers for job talks that I got that I knew I couldn't accept. So I actually turned down quite a lot of them. This may not be you. You may be on a plane, every week from November to, January. That might be the situation that you're in. For those of you who have done practice, it's a lot like that. It's a whole day long interview thing. Pace yourself, know your stuff, you'll get through it. I am happy to talk sort of more about that to the extent that people have questions. Different schools sort of format that differently, and so you kind of have to be ready to adjust. based on the circumstance. I think the last thing that I will touch on is when you get offers. This usually involves sitting down and talking to the dean, who will sort of outline the scope of your offer, and you will find that the offers you get can vary wildly. If you have more than one, you are in a position to negotiate, and you should. I think, I won't talk in detail about that, but keep this in mind, that if you have more than one, you're in a position to negotiate, and you can sort of negotiate all kinds of things. You can negotiate on things like leaves, teaching load, what classes you want before you're tenured, things like that. You will find that some deans have some flexibility and some really don't. You will find the same for deadlines. You will find that some deans will give you sort of as long as you need to kind of figure it out within reason, and you will find that some deans want an answer within 2 weeks. So you just need to be sort of prepared for the gamut, right? It can turn out a lot of different ways. I think with that, I'm probably out of time, so I'm going to turn it over to Alina, and I'm happy to take questions about any of this.
Thanks, Emily. Good morning, everyone. My name is Alina Ball. I'm a clinical professor here at Berkeley Law, and for many years, I had the privilege of being a clinician at UC Law SF with Dean Ratner and Emily. The area that I teach in is transactional work, so I work with small businesses, just to give you a sense of my background. If your interest in legal academia is rooted in a passion to work closely with students and a commitment to leveraging the law as a tool for social change, then a clinical teaching position might be an excellent fit for you. However, it's common for academic candidates to have limited exposure to the breadth of opportunities available within clinical legal education, and therefore they don't have enough information to make the connections between their interests, their experience, and what I believe is the best job out there. So in my brief remarks, I want to, one, provide you with an overview of the various types of clinical positions. Dean Ratner's already set that up well for me, so I'll try to go through that part fast. Two, describe some of the formal pathways into clinical teaching. And lastly, just leave you with a few words about the importance of clinics wherever you end up teaching, whether that's podium, doctrinal, or something else. Okay. And I'll do all of that by quickly telling you a bit about my background as a personal and hopefully interesting gateway to illustrate these points. Okay, so when I was applying to law schools, the possibility of being a law professor could not have been further from my mind, okay? So I was looking for law schools that would be a good training ground for a future civil rights attorney, and I selected UCLA precisely for that reason. And then I proceeded to immerse myself within the critical race studies concentration, where their tagline for years was think, teach, transform. And I was down with the thinking and down with the transformation and not at all interested in the teaching, right? Like that, they weren't talking about me. Okay, so but you know, the program in its wisdom is structured to cultivate, among other things, to cultivate future academics. And as a result, one of its features is really fostering relationship between the core CRS faculty and students within the specialization. So most CRS courses, or at least at the time, I'm giving you, this is like 20 years ago, but at the time, most CRS courses were limited enrollment, right? So they were small academic environments. Core faculty taught multiple CRS courses. So you could really develop, you know, an intellectual relationship. They could see you grow as a student. And there were ample opportunities to form relationship with your professors outside of the classroom. So planning symposium together, you know, just doing other kind of fun activities. They were great. So my core CRS faculty were critical in helping me transition to academia, and in fact, they, you know, saw this coming long before I did. So if you haven't already, make sure that you are working with your law school professors as you maneuver, and for those of you who raised your hand as to not being on the market, even better, right, as you're preparing to maneuver the market. Depending on the quality of the relationships that you cultivated with professors while you were in law school, your faculty members, your former faculty members, will write you letters of recommendations for your appointment committee. They will pick up the phone and make calls to key faculty members where you're interviewing, and they will provide an insider perspective into the options and the experiences that you're having when you're on the market. It's truly invaluable. And in fact, in a lot of ways, that's what you're really paying for when you went to law school, right? You're paying for the access to build relationships with these individuals. And I'd say second to the quality of your job talk paper, which I know the second panel is going to talk about, so I won't even discuss that. Your relationship with your law school professors is perhaps the most significant determinant of your success on the market, right? Law professors as your champions are key to your success on the market, regardless of what type of teaching position you are trying to secure. Okay, so hopefully that's a takeaway that you're taking from this. Now, when I was a student at UCLA, I worked closely with two preeminent clinical professors, Jerry Lopez and Scott Cummings. However, neither of these professors had me in a clinical course, right? So I took 2 seminars with Jerry Lopez, and I took business associations with Scott Cummings. I did, however, take a live client clinic while I was at UCLA, but I took that course with the doctrinal professor, Professor Carol Goldberg. Now, as a law student, you may not have taken a clinic. Clinics are not required at most law schools. Depending on when you went to law school, they may not have even had a very well-developed clinical program at your law school. And you may not have even registered these distinctions between the different types of professors you were working with, right? Most students will assume if I'm taking a large doctrinal course, I'm taking this with a traditional doctrinal professor, right? So if clinicians teach doctrinal courses and write legal scholarship, and if doctrinal professors can teach live clinical courses, then what's the distinction between clinicians and podium professors, right? Well, I think there is one, right? So the organizing principle of clinical professors is that we are deeply invested in the study of the legal profession, the practice of law, and how the law and legal institutions interact with and impact the experiences of marginalized communities and individuals. So the driving force of clinical legal education is not teaching lawyering skills, although it's absolutely what we do. It's about developing the professional identity necessary to advance justice. While this is a commitment to, like my commitment to justice is something that I thread through any course that I'm teaching. So whether it's business associations and I'm talking about shareholder proposals, or it's my seminar on American legal education and I'm asking students, okay, what are the outcomes that our current structure of legal education produces, right? It's in my clinical course where I have students working in teams to represent live clients that I have both the time and the relationship with students to explore what big ideas of the course mean to their professional identity. Who is the lawyer that you want to become? And what support systems do you need to make that a reality? Right? So there's a variety of teaching positions. Dean Ratner did a great job of describing those. All of those are present within clinical teaching. And there's considerable diversity for how clinical education is structured at different law schools. But I do think there's 4 general categories worth noting. So I'll mention all of them and then take a bit more time describing the other 2. So there's experiential instructors. So these are contract professors, as Dean Ratner described, who are not core faculty members. And this is how fellowship programs and visiting assistant professor or VAT programs are often structured. So I'll come back to that in a second. There's long-term contract faculty, which via contract can sometimes mimic the job security and the academic freedom of what we think of as tenured professorship. And the distinction here often between clinicians and their doctrinal counterparts is their teaching loads, as long-term contract faculty tend to have heavier teaching loads weighted heavily towards clinical instruction. And then also different salary bands. Then there's tenured or tenure-tracked clinical professors, right? So this category includes faculty that hold tenure or on tenure track, with clinical teaching as a central component of their academic responsibilities. So these professors typically have the same status and institutional rights as doctrinal faculty, and their clinical work is integrated into their broader teaching and scholarly portfolio. So examples here would be where I started us with talking about Jerry Lopez and Scott Cummings, and it's sometimes often identified as unified tenure track, or unified tenure. And then the fourth category worth noting would be doctrinal faculty with clinical engagement. So some law schools structure their clinics around staff attorneys as the primary staffing of the lawyering of the clinic. And then they work in collaboration with doctrinal faculty. So in these models, the doctrinal professor might teach the seminar component of the clinic and engage in limited student supervision, or while the supervising attorney or attorneys often carry the majority of the student supervision and the caseload. So this is the model that I had when I worked with Professor Carol Bloomberg, right? She was working closely with an adjunct professor that was doing the supervising of, the day-to-day lawyering, and she was teaching the seminar component of the clinic that I took. Alternatively, you can have a doctrinal professor that periodically rotates into a clinical course. Maybe every couple of years, they directly supervise live client matters, just as part of their kind of regular teaching load. So it's something they kind of rotate in and out to. So your pathway into clinical teaching depends on what type of clinician you're interested in. A tenure track clinical position will require you to be able to, first of all, will almost certainly mean that you'll need to go on the market in the same way that Professor Strauss already discussed, right? And when you're on the market, you'll need to be able to demonstrate practice experience in the subject matter, right? So several years of relevant lawyering. And also a track record, or at least a very strong desire to produce legal scholarship. Right. So for all the other reasons Professor Strauss already summarized, while you're a practicing attorney, you don't often have the time to develop a quality job talk paper. This is why many aspiring clinicians will pursue a visiting assistant professorship position or a fellowship. So, for example, the fellowship that I did at Georgetown was structured as an LLM program where I taught and supervised clinical students, but also completed coursework in clinical legal education. The idea of these programs is that they provide you with both the time and the support structures to then be competitive for a tenure track position. So recall that I started talking about the importance of law professors as your champions. If by any chance you did not form those deep relationships while you were in law school, getting a VAT position or pursuing an LLM or getting a fellowship is another bite at the apple to have strong scholars and legal academics really believe in you and believe in the work that you want to do. And I'm happy to talk during Q&A about questions for applying for VAPs or fellowships, because they're not all created equal. Okay, so in closing, what I will just say is, even if you're working on a PhD right now and have never lawyered a day in your life and so are not at all interested in clinical teaching whatsoever, I will say that it's worth paying attention to the quality of the clinical program at the schools that you're interviewing at. Why? Because the strength of the clinical program will impact the quality of the students you see in your classroom. Trust me, you want to have my clinical students in your SecReg course. You want to have my clinical students in your corporate governance course. Why? Because they are the students that are going to be asking the sophisticated questions and engaging with the materials that you're teaching, because they understand from practice, right, how what you're teaching is relevant to what they will be doing, when they leave law school. So I'll stop there, and happy to discuss any of this during Q&A with you.
So we built in, we're on schedule because we cleverly started early. So we have half an hour I have questions, but before I ask mine, the floor is open.
Thank you, all of you, for your perspectives. I was wondering if you could talk a little bit more about the, I know we talked about writing and how important that is and bringing in. Are you talking, or do you think that it's valuable to have
For me? Okay. I would say all of the above. And let me sort of lay that out a little bit. It's better to send drafts to people when they're reasonable drafts. So it's always nice if you, and I have always benefited from this. I have a couple of close readers who I feel comfortable sending raw drafts to. Develop those people. They are very helpful because they will help you kick your raw draft into a format that you don't feel embarrassed to send it to people that you don't know. But do that. I would restrict your raw draft readership to those one or two very trustworthy people. After that, send it to the people who you cite, right? And I think that's helpful at all stages for all reasons. I think, before you were contemplating going on the market, right, it helps you develop a reputation, right? When you are on the market, it makes other people think that you're productive, which is awesome, right? People sort of get a feel for your work. And the real reason to do it, honestly, independent of all that stuff, is that it makes your papers dramatically better. It makes your papers dramatically better, and it educates you. I think that one of the things that I underestimated coming into this profession was and I've spoken about this before, but the depth of the literature that you need to have a grip on to be a really good academic. And that is a challenge earlier in your career because there's so much of it, right? And it's hard to sort of zero in on what you really want and need. And the commentary that you get from those people is invaluable because they will kick you over to some law and economics and accounting article where you were like, I would never, ever, ever in a million years have found this on my own, but actually it's precisely on point. I'm going to cite this, and now I'm going to send it to one of the authors of that article, right? And so I would say it really, it makes your papers better. It develops your reputation. Do not send people who you do not absolutely trust raw drafts. Get them good first.
And a VAP program is a great way, or a fellowship program is a great way to figure out if what you have is an early stage draft, a draft that you can send to folks, a draft that you can send to people, right? So it's really hard to gauge this type of stuff without a lot of support and structure and understanding, right? So that's why fellowship programs can be very, very useful to the average, I don't know, none of you guys are average. You're trying to be law professors. But to the average aspiring law professor, it really makes the difference between trying to figure out, well, what stage am I at, right? Because if it's a good fellowship program, I went to an excellent fellowship program. If it's a good fellowship program, you're working very closely with a tenured professor who's aligned with what you're interested in doing, and they are the set of eyes that are giving you that feedback, right? So you could, as Emily's saying, send it out to folks. I still don't do that, actually, just like cold call people. But another way of doing it, and the fellowship will give you, and working with a professor will help you kind of figure this out. You could also present your scholarship, right? You can go to workshops. There's a whole concept that we do in our profession where we workshop papers, and sometimes we workshop early drafts, right? And sometimes we present, full drafts. So there's different versions of how we do this. And, the faculty member that you're working with will help you maneuver that. They'll be able to help you say, oh yeah, no, the draft is absolutely ready to present here. It is not ready to try to present here. Right? And so we'll help you sort of structure that. And that's another way to really develop your network and make connection with folks. Because you might know chances are you'll know there are going to be some folks that you'll know by working with your faculty member and reading the literature that you want to make a connection with. But there's just so many other people doing work out there, right? And so it could be that you make a connection with someone in the room. Someone walks up and is like, I was really interested in that thread of what you were saying. Let's have coffee or lunch, right? And so, those are the sort of things you might not know. So another way of doing that is, workshopping your paper in a fellowship or a well-designed VAP program will give you an opportunity to do that. The other thing I will just say is that what your sort of, I'll just say, sort of catalog should be in terms of your academic writing really depends on what type of positions are you trying to be competitive for, right? So based on kind of where you're trying to enter the academy, there's different answers to this. But if you are interested, let's just say, because this is just how we work in our profession, everything's ranked. So let's just say you're interested in like a top tier school, right, a top 50 school, and you're interested in an entry level position there. Chances, to be competitive, you'll probably want to have published 1 or 2 pieces already, and then have a job talk paper, right? Like in other words, you might have on paper the requirements you would need to get tenure to get your entry-level job, right? You might have 3 papers to get your entry-level job. So I guess what I'm just trying to say, right? So it also depends on where you're trying to enter the profession in terms of what is the track record that you might need to have, right? And maybe that's something that you started in law school, right? Because you published a note, right? And then maybe you co-wrote something while you were practicing, and then maybe you did a fellowship and you have a job talk piece that's polished and ready to go, but not yet published. And then you have something that you've already started sketching and it's a rough draft, right? But it's not uncommon to have entry-level candidates that have like 4 pieces and they're entry-level candidates. So it really kind of depends.
I just wanted to quickly second the point about workshopping. The nice thing about workshopping is that it's less easy for your audience to tell how developed the paper is. And so when you only have 15 minutes to talk about it, you can create a slide deck that gets your general point across, and then everybody will feed you the details of how you improve it. So there's that.
And it may have been obvious from the prior comments, but the job talk paper typically is a draft because you want, when you're getting feedback, to be able to say, oh yeah, that's a great point. I'll mix it into my next iteration,
If you say that, do it.
Yeah.
Don't acknowledge the advice and ignore it. They will remember that. There are several, please.
Alina, this question to you on the fellowships. That sounds like an intriguing idea and hadn't really sketched out or thought about that. How do you go about finding one? Are they listed on the ALS? Do you apply through there, or is it again a hunt through individual law school websites?
Yeah. I wish there was like a centralized way to do this, and I'm not familiar with there being, but you could just literally just start with Google searches, and depending on the type of fellowship that you're interested in, there are going to be some key ones that you should be on your radar. So, for example, if you're interested in clinical teaching, you should have Georgetown's program on your radar. It's the premier clinical fellowship, right? But other law schools have them. So Yale has a clinical fellowship program. Fordham has one. Harvard has one. University of Michigan has one. So depending on the area that you're interested in, and this is a great conversation, depending on what you're like, where you want to work, to have with that law professor that I'm talking about, like from school, that you can pick up the phone with and be like, Jerry, how do I do this, right? And he'll be like, oh, NYU, Georgetown, Yale, there you go, right? So your contacts will help you figure this out. And then in terms of VAP positions can exist in a more structured way, similar to fellowships, but tend to be a bit more ad hoc because they might be connected with particular funding streams that are available one year but might not be available another year. So, for example, I can't help but do this, Dean Ratner, but UC Law has a VAP program through their Center for Racial and Economic Justice, right? So this is a 2-year VAP program that's designed to foster academics that are interested in working on racial and economic justice issues in their scholarship and explore issues of identity subordination in their scholarship. So there are some established programs. UCLA has one for their CRS program. It's it's a VAP program. I'm pretty sure it's structured as a VAP program. So there are some pretty established, I believe the Williams Institute has an established VAP program. So there are some established ones, and then the Hastie's Fellowship, right? There's ones that have been around for 30 plus years. And then there are other ones that sort of come up as schools say, okay, we have some bandwidth this year to hire 3 or 2 VAPs in these areas. So it can fluctuate year to year, and it's helpful to have somebody on the inside that's kind of pointing opportunities your way. And then, I would say, depending on your area of interest, running some searches, connected to that. Yeah. And then they have a variety of application processes, but most of them will require you to articulate, like a cover letter, which will ask you to talk also about your area of scholars, like what area of scholarship are you interested in pursuing, what type of courses would you be interested in teaching if you got the fellowship, a resume, and then we'll ask for academic references, which is, again, why it's helpful to have gone back to your connections in law school. Sorry, you in the back, in the black. No, you just put your hand down, but you have had your hand up several times. So I want to make sure you get your question.
It's actually just what you were just talking about, because you mentioned before that not all VAPs and fellowships are created equal, and I was just wondering if you could expand on that a little bit.
Could you repeat the question?
Not all VAPs are created equal. And so could I just talk about that a little bit?
Go ahead, yeah.
So Dean Ratner should also answer this. So Dean, okay, so hopefully he will too. But so some VAPs are created to fill curricular needs on a short-term basis. Like we have several faculty who are out, business faculty who are out. We need to cover 3 sections of business associations over the next 2 years. We'll do this with a VAP, right? So it's not about supporting, the design of the program is not about supporting future scholars. It is about filling a curricular need on a short-term basis in a relatively inexpensive way. So it could still be a very useful position to take, right? But that's very different than, for example, the program that UC Law has at their Center for Racial and Economic Justice, where you have scholars that are interested in developing, like current scholars that are interested in developing a pipeline of new scholars, right? So the experience that somebody has covering for business association or, business-related courses at a school, and they're just teaching, they may or may not be connected with any other faculty. There may or may not be anyone else kind of guiding them or even asking them, what are you interested in? What do you want to? That's very different than, for example, UCLA's program through their CRS program, where they are looking to produce, the top candidate that is doing critical race theory, right, on the market that year. And then you have a whole program that is then pouring into that candidate to produce that top candidate. So it's a different experience, and then, based on what you're interested in, that can help guide the type of programs that you're applying to.
And just to bottom line it's the degree of mentorship baked into the program. Regardless of the number of credits you're teaching or whether they're giving you time for scholarship, the key is that if you're looking at various options, you want to know you're being paired with senior scholars who will both mentor you on teaching and your scholarship.
Okay, somebody else pick.
Oh, right there. Yeah.
Thank you so much for all of this advice. It's been wonderful. I wanted to ask about effectively deploying your faculty mentors and recommenders when you're going on the market. When in the process is kind of the better time to ask them to pick up the phone or send a letter? Are you doing it at the FAR form stage, at the screener stage, at the job talk stage? And then what are the expectations or norms about how many times you can ask somebody to pick up the phone for you? When are you starting to wear out your welcome, and what's normally expected there?
Well, okay, can you hear me? All right. I'll take a crack at this, but in terms of wearing out your welcome, I'm ill-equipped because I haven't been on the other side, right? I think that, I mean, these are obviously people, and Alina has spoken about this, that you have known ideally for quite a long time, who are your friends, who are, you know, really your allies and people who are willing to back you up. I think for me, all of the people that I asked to be my references when I was on the market were people who had offered to be my references. And you will have people like that. And that I think helps the dynamic. I mean, because that was sort of how I did it. You know, I didn't feel like I was imposing on them dramatically when I was saying, okay, these are the letters I need you to write, and can you call somebody now? And both because of the closeness of the relationship and because, again, they had volunteered for this. So that I think helps. In terms, I mean, they will write you a letter. You know, there were some times when I did call a couple of my references and say, hey, look, can you talk to so-and-so about this, or do you know so-and-so, or whatever. I think one of, and again, I can't sort of speak to the replicability of this experience, but one time when my references were extremely useful was on the tail end of the process, when I was sort of getting and negotiating offers and trying to figure out, sort of being able to have people with whom I could brainstorm what I could ask for, or what I should ask for, or what else I should try in this certain situation, right? Because it can become logistically extremely complicated, right? Trying to figure out which job you're gonna take. And being able to have people to sort of bounce ideas off of is really helpful. You know, there also is a piece of this which is where you don't know what their network is necessarily. And so you go to them and you say, look, this is the issue that I'm having. Is there anything you can do about it, right? So I think, again, and all of that is dramatically easier if these are people that you know well. And it's even easier if they are people who were like, let me do this for you. So I guess that's what I will say about that.
Yeah, I would say in an ideal world, you're actually not asking them to do very much, because they are doing it for you, because they are already your champion. They are already like invested and excited about the possibility of you teaching young, aspiring legal scholars, right? They're already jazzed about this. So in some of the ways that my champions were the most helpful in ways I didn't know about until afterwards. Right? I didn't know about some of the phone calls that they made. So it's sort of what is unseen, but I'm telling you it makes a difference. So if you have strong relationships, or if you have somebody you have a relationship with, I would encourage you to continue. And if somebody's reached out to say they're willing to be a mentor, take them seriously, and use them. So I would say when I was in the process, what I could see from my vantage point is feedback on my paper. So if somebody is willing to read your paper, especially if it's your first one, like that is a lot of commitment. They are telling you they are invested in what you're doing. You should take that person very seriously if they are reading your draft, especially if they're reading multiple versions of your draft and they're giving you line edits and they're talking to you about it. Like that is somebody who is signaling they're very excited about what you're doing. They really believe in you. So that was very helpful, getting edits on the paper. The other reason why it's helpful, and I didn't understand any of this as strategy, because like I said, I did not even know I wanted to be a law professor. So I was doing this on a wink and a prayer. But what you're also doing is you're getting people who are going to write letters for you very familiar with your scholarly agenda, right? And so they knew that's why they were doing it and giving me feedback. I didn't quite understand this, but then when a hiring committee asked them, okay, we have this candidate, here's their paper, can you review? They've read versions of, they have a very good idea of what you're trying to do. They've already thought about where it fits into the literature, who you're in conversation with. So I didn't quite understand that nuance, but are they reading drafts of your paper and are they giving you feedback? That is a very high-touch individual if they're doing that. And are they helping you prepare for this? So are they offering, number one, or willing to attend moots for you, So when I went on the market, most of your law, no, I shouldn't say that, but several of your law schools will have programs to support you becoming an academic, right? So if you tell your school, I'm thinking about going on the market, can I do a job talk? They'll take that very seriously and they'll help you put one together. If you've already told your law professors that you're on this, they may have already offered to do it for you because they know that this is a system that the school does, right? So before I did I had already done callbacks, but before I did I'd already done my first round interviews at the meat market. But then before I did callbacks, I went to UCLA, and this was like the toughest room I was going to have on the market, right? No, anyway, so it was a tough room because these are scholars that really engage with the issues that I'm like interested in, and they're reading my paper and they're treating it very seriously and giving me a lot of feedback. So that is something you can ask for, and you'll see on this side of it. And then, as Emily said, talking it through some of the offers or some of the experiences that you're having. So what you might not see on the back end of it is that they might be asking their colleagues to read your paper and give you feedback, or just talking to your colleagues about your paper. Your colleagues at their school, but at other schools. Once you are on the market and you say, oh yeah, I have a callback at X, Y, and Z school. And again, this was something I didn't even know. It's like some of them were there. They'll call up their colleagues there, and they'll be like, "Hey, Alina's coming through. Like, she's the real deal. Like, take it seriously, right? Like, or tell me if she doesn't do well, right?" And so they are they're trying to understand what's going on. So there's that kind of happening, yeah, those are kind of the big things. Yeah.
I'm going to invoke the 10-minute rule. Let's group 3 questions, and our panelists can respond, because I saw there were several hands. Let's see, 1, 2, 3. Okay. Please.
So when you're packaging yourself for the first time, if you have broad interest areas, like you can see yourself going down, let's say, experiential track A, maybe doctrinal area B or doctrinal area C, how broadly do you package yourself, or is it better to hone in on one specific track when you're putting yourself on the market?
We live in a tumultuous time for universities. I'm curious if anyone has reflections on how the market will be impacted by the political context we live in, whether it's the specter of funding cuts or demands from the administration for so-called ideological diversity in professor hiring.
Professor Strauss mentioned the off-market hiring process. Is there an actual process there to understand, or it's just you've got connections on faculties who will convince their schools to hire you because they love you? How do you navigate that?
Okay. All right. I will take that one first, which is to say that it's not usually that. It's usually someone that you know who you've met at a conference who emails you and is like, "We're looking for a business law professor. Are you interested?" And then after that, it looks basically like the normal hiring process, right? You do a screener with the hiring committee. They bring you for a job talk, and from there on, it's very sort of my experience was timing-wise, it doesn't coincide with the market for obvious reasons, right? But if they've had a failed search, right, someone might reach out to you because you know them, right? Because they've met you at conferences, or you've sent them their papers, and they might be like, "Well, look, I know you're not on the market this year, but would you be interested?" And that is the process. And the other one I wanted to sort of very briefly touch on is, when you are packaging yourself for the market, I would advise you to hone in on something specific. And that's all I'll say.
Agreed. I think your FAR form should be broad, because at least the way it was when, I think it's still like this. It's Boolean searches. So literally, committees are using different words to pull FAR forms that fit within, that use these words in there, and that they have these words in them. So I think it should be a broad form, but it should be clear that you have an area of expertise that you can go very deep on. So, for example, when I was on the market and I knew I wanted to do clinical teaching, but I I also interviewed for doctrinal positions and seriously considered doctrinal positions. So clinical teaching was at the top of my teaching preferences, and then the other areas that I was interested in were also on there. So it's a broad form because you're trying to get eyes on you, right? But you clearly have an area of expertise, right? You're not going in as a generalist.
I will just say on that one question, as a provost and academic dean, I'm always excited to see someone who's willing to teach a broad array of courses, even if their scholarship is
Right.
quite focused and concrete in a particular area that shows depth. And on the question about the impact of the current political environment on law schools, I will just say that this does feel like a turning point, not just for that reason, but for other reasons that people considering the law teaching market should just be aware of. There are real threats to academic freedom. There are also threats to higher ed funding that could shape higher ed in general and law schools in particular in ways that have yet to be revealed. One of the most significant is the big beautiful bill's change to federal financing of graduate education with new caps, and the effects of that are not yet known in terms of the impacts, but it could either reduce the number of law school applicants or at least change the applicant pool to people who have access to non-federally supported forms of credit. And it could also place pressure on higher ed and law school cost models, which is something to think about. And also restrictions on or deterrence to people coming to this country from abroad could also impact the size of LLM programs, which for many schools help fund their JD programs, which could lead to all sorts of effects that are yet to be revealed in the market. We've been through many so-called crises in legal education, and in my experience so far, they've all turned out to be just fine. Everybody still needs a good lawyer, but it is an interesting time to be in legal education, and I do not know what legal education will look like in 10 years.
You guys are going to keep us on time. I'm going to take moderator's privilege for just a sec because I want to pull out a couple of themes that we've heard from our panelists. One is to be flexible. There's uncertainty going forward, but also law schools are all around the country. You want to think about how willing you are to be in different locations and what constraints you might face. But the biggest thing I've heard time and again from each of our panelists is the importance of preparation and practice, right? It takes a village to get a law teaching job. You need people who will read your drafts. You need people who will practice the job talk with you. Do your homework, right? When we hear references to the literature, read the scholarly work that's already out there that's related to your area. Make sure you know what the significant works are. Be comfortable talking about them. That's the literature review. Leverage the contacts you've already got, right? Find out who your allies are and exploit them. If you have former professors, they will help you. And they will be happy to hear from you that you're interested in law teaching because it is vindication of our life choices that you want to be a law professor. And the last thing I'll say, and it's already been touched on, but I want to double down on it because it's something I didn't appreciate when I was on the market a while ago. Think about how you frame yourself. What sandbox are you playing in? What kind of scholar are you? Because that tells the hiring committee, how do we think about this candidate, right? Is this a private law, business law person? Is this a public law, con law person? Is this an admin person? What kind of person is this? And some of you may be resistant to that, right? Some of you may be thinking, I'm smart, I'm good, I write well, let's go. And that's not how the hiring committee is going to think about candidates. So we have a 15-minute break. That clock is wrong. We have a 15-minute break before the next panel starts at 11:30. I think there should still be coffee outside. Thank you. Let's please thank our panelists.